Good morning, everyone. Today is Tuesday, March the 13th, 2018, and it's 10 a.m. It is my pleasure to call to order today's meeting of the Tennessee Department of Commerce and Insurance Board of Funeral Directors and Embalmers. Mrs. Bohannon, will you please call the roll?
Dennis Bridges. Mark Carthron.
Here.
Robert Davis.
Here.
Jeff Duffer.
Here.
Clark McKinney.
Here.
Charles Rahm.
Here.
Robert Shackelford.
Here.
Mr. President, 6 of the 7 board members are present.
Thank you, Mrs. Bohannon. First order of business is the adopting today's agenda.
So move. Second.
I have a motion by Mr. McKinney, a second by Mr. Duffer. All in favor?
Aye.
We have the minutes from the January 9th meeting. I think all of you have had a chance to review those. I would entertain a motion.
Motion to approve is presented.
Second.
I have a motion by Mr. Shackelford, a second by Mr. McKinney. All in favor?
Aye.
Legal report. Mr. Clandrell.
Thank you. I'd just like to stand up for one moment, if I could, at the beginning and introduce one of our newest attorneys here at the Department of Commerce and Insurance. Again, my name is Tony Glandorf. I'm the Chief Counsel for Regulatory Boards Division. And to my right is Ashley Gino, all the way down on the end. Ashley Gino this is her second day with the department. She started yesterday. She will be assigned to this board and a few others as a disciplinary counsel. Her primary responsibilities will be processing the complaints that come into the office, presenting those matters to you on the legal report, and then litigating any of those cases that need to go forward through a formal hearing. Ashley is a graduate of the University of Memphis School of Law, which I believe is the best school of law in the state of Tennessee, since that's the one that I attended. She is a 2014 graduate and also a 2014, she's been licensed since 2014. She comes to us from here in Nashville. She previously worked at Brewer, Krause, Brooks, and Chastain doing insurance defense in litigation. So we're really excited to have her on board, and we're excited to be able to fill this position that Sherelle Hooper has so graciously giving me her time and patience to assist in providing the legal reports, and we'll be doing that dually together, and then at the next meeting we'll be presenting it with Ashley, working with her on that. So do you all have any questions for me regarding this? If not,
Just welcome you and look forward to working with you. And I know as you kind of get settled in, we would encourage you to move forward with our cases and get things accomplished for us.
thank you very much. I'll go ahead and sit down, and I think Sherelle's going to do the first half of the legal report, and then I'll finish out with the second. Thank you.
Good morning.
Morning.
So we have 14 cases today, and I will be going over the first 9 with you all. We'll start with number 1. This case is against an establishment. It's case number 2017-069391. There is some disciplinary history, as you can see, and I will go ahead and summarize this case as follows. The spouse of the decedent filed a complaint stating that the funeral establishment failed to change the death certificate to reflect that her husband was pregnant at the time of his death. The funeral establishment responded to the complaint and indicated its intent to work to satisfy the complainant's request. No additional information has been provided to the board office. Our recommendation is to close this complaint because the portion of the death certificate that relates to pregnancy not completed by the funeral establishment and or the funeral director.
They get this situation worked out with the physician?
We're not sure. We know that because the establishment and the funeral director don't have that responsibility, we didn't further look into the issues really.
Okay. Motion to accept council's recommendation.
Second.
I have a motion by Mr. McKinney, a second by Mr. Cochran. All in favor?
Aye.
Thank you. For case number 2, it is against an establishment. The case number is 2017-07-2281. In that case, complainant alleges a number of errors were committed by the funeral home in connection with her mother's funeral services. She alleges the following. Number 1, the interior of the casket was not inscribed with the word mother. Respondent indicates complainant never informed him of her final decision on the cap panel. Number 2, the Afghan was not inscribed and did not have the pictures on it as requested. Respondent indicates that the Afghan was a gift from the establishment and there was no charge. Complainant was not pleased with the outcome, and respondent believed this was due to trying to fit so many pictures on the Afghan. Respondent reordered the Afghan, but complainant was still not pleased with the product. Number 3, obituary had misspelled names and listed the incorrect age of the deceased. Respondent indicates complainant was informed of the deadline for placement of the obituary. When complainant missed the deadline provided by the respondent had to call the complainant the next day and obtain the information over the phone. Respondent states complainant was not sure how to spell several names, but requested that the information be included as she dictated. Complainant acknowledged to respondent that she missed the deadline because of family and friends coming to her home to visit. Number 4, program had errors such as incorrect font and did not use the pictures that were requested. Respondent indicates that the family was late providing the information to them. The night before the funeral, around 11 p.m., complainant emailed edits to the program along with approximately 25 additional photographs that she wanted to be placed in the program. Respondent printed the 8-page program free of charge for the family. Number 5, complainant alleged that the driver arrived late to transport the family to the funeral services. Respondent indicates that the driver was late because complainant requested an additional limousine at the last minute. Respondent offered to have the first limousine arrive in time to take the first group to the church, but complainant wanted to wait on the second limousine so the family would arrive together. Number 6, video quality was poor and unprofessional. Respondent indicates that complainant was made aware that the funeral home needed the photographs, but the funeral home still had not received them by the time of the viewing. Because of time constraints, the photos were emailed from complainant's cell phone to the funeral home, so the quality was poor. Because complainant was not satisfied with the video, the respondent made a second video. Respondent did not charge complainant for either video. Number 7, there were no flowers on her mother's casket at the wake. Respondent indicates this was agreed upon because complainant wanted the flowers to appear fresh for the funeral. The flowers were on the casket for the funeral. Number 8, the death certificates were filed late. Respondent states this was because of the new program that had just been implemented by the State of Tennessee Vital Records, as well as the doctor's delay in signing the death certificate. Evidence confirms that within 20 days of death, respondent followed up with the doctor on the status, and shortly thereafter, the death certificate was filed. Finally, number 9, the statement of goods and services was amended after execution to include several additional charges. Respondent indicates that the family was made aware that some of the cash advances would be added to the funeral bill as the charges were incurred. These amounts were for the musician, the newspaper notice, and the cemetery, and were approximately $1,100. No additional charges were added for funeral services or merchandise. Respondent further indicates that because complainant was so upset, he decided to write off the amount of $1,623.09 for the funeral, which cost a total of $8,123.09. Our recommendation is to close this complaint.
It sounds to me that the funeral home tried to take care of the family and satisfy this. So I'm going to make a motion to accept this recommendation.
Second.
I have a motion by Mr. Duffer, a second by Mr. Cochran. All in favor?
Aye.
Case number 3 is also against an establishment. It's 2017072921. There is no disciplinary history. I would summarize it as follows. This complaint was filed by a casket supplier due to a funeral establishment's failure to pay for goods received. The alleged outstanding balance is $21,241.60. Respondent indicates that the failure to pay was caused by a sudden physical disability lasting for months. Following hospitalization, the decision was made to close the establishment and the owner remains unable to work. Respondent has offered on 2 occasions to return the unused items, which he indicates are still sealed in the box, to the casket supplier. However, respondent alleges that complainant would not accept them back because they were special order items. Our recommendation is to close with a letter of warning.
Because the establishment is closed, who is the letter of warning to?
Well, it's still to the establishment. One of the issues the board office has run into is that the establishment has not completed the form that would surrender the establishment license, and so it would still be to the establishment, and we would likely include another copy of that document that would need to be completed in order to surrender the license and officially close the establishment. In other words, the license is still active because the respondent has not voluntarily surrendered the license, even though the board office has made a couple of requests for that to be done.
You anticipate getting those forms from this establishment?
We're not sure why these forms haven't been completed, but that would be one of the goals. Since the establishment is closed, according to respondent, one of the goals would be to have it officially be closed on our books as well, as opposed to still showing as an active license.
Is there a possibility that the respondent is waiting to become healthy or open the business back up, or?
We actually thought about that, and from the communications we've received, this seems like it's a permanent closure. But that could be a possibility. So I think the board office would need to have further communications with the respondent. I mean, with the respondent, and get additional information as to the respondent's intentions, since the respondent hasn't completed the form as requested.
Timetable be placed on that for the respondent to go one way or the other, instead of just letting it lay out there?
I think the board could give this individual a time limit to voluntarily surrender the license. I think that would make the closure official, the closure of the establishment official, and if not, the respondent would have the opportunity to then communicate his intentions, and that would help the board in the future know how to proceed with future complaints.
I know the board in the past has issued civil penalties in cases like this, because I think we have a rule in place that basically says you got to pay your bills. What's the difference in those cases and this one?
I'm not familiar with the previous cases necessarily, but I would say with this one, the particular reason provided for not doing this, and the fact that the individual has indicated that the establishment is closed due to a physical disability, I think that makes it different from other cases where perhaps individuals simply haven't paid their bills for whatever reason.
Your recommendation for this letter of warning, what does the statute say? Somebody, do you have that with you?
In reference to what do you mean?
As far as the caskets not being paid for, what are you basing that letter of warning on?
The rule says essentially under the professional conduct section that suppliers should essentially be paid. And so it's listed under the professional conduct section.
What's the time period on that should be paid?
Not sure exactly. I don't think there is one, though. I think it says timely, but I don't think there's a specific number of days.
I think if the supplier has filed a complaint, it's probably been quite some time. I would think they would exhaust most means before they file a complaint.
Also, not sure of us putting a civil penalty on this gentleman who is clearly already having a tough time is going to help him pay his bills in a more timely manner. I'm going to make a motion to accept council's recommendation.
I still would like to hear that rule. Mr. Wilbur, do you have that in front of you?
I have it in front of me. It says that all persons engaged in the profession of funeral directing, embalming, or operation of a funeral establishment shall at all times act in a professional manner, including but not limited to, and we're looking at B, which is establishments shall honor financial obligations to suppliers, distributors, or other persons with whom they conduct business in a timely manner.
I'm in agreement with Mr. Cochran. I'm not second, but I would like to, Mr. Cochran, I would like to put a time frame on this motion, and I'm good with 30 days to either one way or the other. You're either going to be open or you're not.
To make a decision on that paperwork. Mm-hmm. Yeah. I'm fine. I'll amend my motion to also include the 30-day timetable. To give it some sort of response on what you're going to do with your establishment.
But it should be a definitive response.
Right. Are you staying open or are you closing? Right. That's what we want. Mm-hmm. Yeah.
And then the casket supplier does have, I understand that these may be special order items, but they do have the opportunity to pick their stuff up, so it wouldn't be a total loss for them.
What was their position? Do you have that in your records? Did you talk to them?
It doesn't say how long they've been trying to get this money collected.
I'm sure that information is in the file, but I don't have it in front of me right now.
Well, just honestly, board members, the reason this individual, more than likely, and this is purely speculation, the reason that he is probably closing his business is to avoid paying these costs. There again, that's purely speculation on my part.
And,
and who's to say he may close for won't be closed for a couple of months, and then next thing you know, he's open right back up,
And I would, point out to the board that, with these type of breach of contract cases, the supplier does have a remedy in a court of competent jurisdiction, which would be able to determine whether or not this establishment has to pay and how much, because there are duties to mitigate damages and there are defenses such as impossibility. And so this is a little bit more complicated than other cases where an establishment simply maybe didn't plan well and can't pay someone. I do have some information as far as dates. The last payment towards the balance listed here, the $21,000, was made on June 2nd of 2017. And so this is going back several months. It's been in dispute for several months.
I just don't want this to set a precedent that that rule that's on the books doesn't mean anything. But I am okay with, every tub sitting on its own bottom too, so.
Is that your way of seconding the motion?
Actually, I think we got a second.
Already got one, I think, yeah.
I did.
We have a motion by Mr. Cochran, a second by Mr. Shackelford. All in favor?
Aye.
Any opposed? Next.
Moving to complaint number 4, that is also against an establishment. The case number is 2017-073821. Would summarize as follows. Complainant alleges there was a dispute related to the cremation of her husband's remains. She alleges that the location manager yelled at her in connection with this dispute. Respondent advises that the deceased was found unresponsive on the couch and later pronounced dead. The physician of record would not complete the cremation letter or death certificate because he had not seen the patient in the past 2 years. Complainant was upset because the process was not moving as quickly as she anticipated. 6 days following the death of her husband, she called the funeral establishment to let them know she was upset and that she wanted an autopsy completed. The medical examiner refused to perform an autopsy and stated that the complainant would need to obtain a private autopsy. 16 days following the death of the deceased, complainant called to find out if the cremation had been performed, and the funeral establishment responded that the cremation could not be performed until the autopsy was done. This upset the complainant, and she requested that her husband's remains be released to another funeral home. This request was honored, and complainant received a full refund of $5,411.08 the same day. Respondent indicates the request for an autopsy stopped the cremation. Our recommendation is to close this complaint.
Motion to accept council's recommendation.
Second.
I have a motion by Mr. Shackelford, a second by Mr. McKinney. All in favor?
Aye.
Thank you. Case number 5 is against an establishment. Is case number 2017-075031. In that case, the executor of an estate contacted a funeral establishment by phone for a copy of the death certificate approximately 6 weeks after his grandmother's funeral. The executor alleges that the county health department did not have a copy of the death certificate because it was not yet in their system. The funeral establishment admits it refused to provide the executor with a copy of the death certificate. It states that the executor is not the legal next of kin, does not have the right of disposition, and he is estranged from the family such that he was not at the funeral. The executorship is being challenged by the deceased children, and our recommendation is to close this complaint.
Motion to accept.
Second.
I have a motion, by Mr. Duffer, a second by Mr. Davis. All in favor?
Aye.
Complaint number 6 is also against an establishment. It is number 2017075871. In that case, a complaint was filed by an individual regarding 2 grave sites that her mother allegedly owned. Her mother is buried in one of the spots, and the other spot was empty. The funeral establishment recently buried another individual in the second grave spot. Complainant submitted a copy of a document purporting to show the sale of the 2 grave sites to her mother. Assuming the transfer/sale is valid, it was the result of a contract between 2 private individuals. Neither the funeral establishment or the cemetery company were involved in the transaction. The funeral establishment's response indicates that the grave site at issue appears to have been transferred or sold twice by the same individual who may suffer from early-stage dementia. A determination will need to be made by a court of competent jurisdiction as to the legal owner of the grave site at issue and any appropriate remedy. Our recommendation is to close this case.
Motion to accept council's recommendation.
Second.
I have a motion by Mr. McKinney, a second by Mr. Duffer. All in favor?
Aye.
Thank you. Case number 7 is against an establishment. It is case number 2017078291. In that case, the complainant alleges she just wanted a basic cremation package for her brother, but the body was not cremated for approximately 3 weeks without explanation. Also, complainant alleges that the body was embalmed without her consent. Complainant alleges that respondent did not return phone calls and forced her to deal with an unlicensed individual at the establishment. Respondent alleges that another family member, the niece of the decedent, authorized the embalming and served as a point of contact. This family member signed a document indicating she had the right of disposition before the complainant ever contacted the establishment, which is evidenced by the documentation. Respondent alleges that the unlicensed individual handled the removal and handled some phone calls, but never met with any individuals to make arrangements. Respondent and the unlicensed employee indicate that the complainant was very difficult to deal with. It is alleged she would engage in behaviors such as yelling and proclaiming that she was a prophet each time she came to the establishment. The medical examiner's office indicates that the funeral home was incorrectly informed of the treating physician's identity. Approximately 2 weeks after the death, the medical records of the deceased were received, which showed the correct treating physician. This physician submitted the signed cremation authorization form approximately 1 week after being contacted. The medical examiner's office indicates that the delay in approving the cremation was due to waiting on the proper physician to sign the cremation request form. And I also want to point out that case number 8 relates to the unlicensed activity summarized in this complaint, and our recommendation with both is to close 7 and 8, but we'll need separate votes on those.
Motion to accept council's recommendation.
Second.
I have a motion by Mr. McKinney, a second by Mr. Duffer. All in favor?
Aye. Motion to accept council's recommendation on the next one.
Second.
A motion by Mr. McKinney, a second by Mr. Duffer. All in favor?
Aye.
Thank you. We're on case number 9 now, and this is against an establishment. It is case number 2017078881. Would summarize as follows. Complainant states she was charged for an obituary that did not run on time, which resulted in less than 50 people attending the funeral service on November 25, 2017. Complainant also states she was charged $150 for facility viewing, but the body was not ready until hours after the viewing was over. Complainant states she was charged for unnecessary things such as $400 for a limousine, and complains of the program charges, which were $250 for 200 programs. She further avers that she was not charged for any death certificates, which will now cost her much more to order individually. The contract shows that the limousine charge for the amount of $400 was approved by the complainant, as well as the charge for the programs. And also, as a side note, the facility viewing was also on the contract. The establishment indicates that it verbally agreed to prepare the body prior to getting a written contract. The decedent passed away on November 18, 2017. Complainant had an appointment on November 22nd at 8:30 a.m., which was the day before Thanksgiving. She did not arrive until 4:30 p.m. without providing any advance notice that she would be late. Complainant chose a casket that was not in inventory and was advised that there could be a problem with timely delivery on the Friday following Thanksgiving. Complainant ordered the casket despite warnings. Respondent states that the clothes were not provided to the establishment until 3:30 a.m. on Friday, November 24, 2017. The funeral director embalmer came to the establishment around 2 a.m. to embalm a case received for the decedent. He could not finish preparing her until the clothes arrived and wanted to do so to make sure the family could view her as soon as possible once the casket arrived. The casket arrived around 1 p.m. The decedent was promptly made ready for viewing, but complainant did not arrive until 3:30 p.m. for the scheduled 1 p.m. viewing. She gave verbal permission at 2 p.m. to begin the visitation and demanded an additional hour past closing to stay with the decedent. Respondent states that upon making arrangements on the afternoon of November 22, 2017, complainant was provided with a schedule of the holiday deadlines for the Tennessean, which specifically state that obituaries would not be accepted on Thanksgiving Day, which was the following day. The establishment states that the complainant refused to purchase the death certificates for $15 and stated she had a classmate who works in the office and could get it faster. Respondent provided us with a copy of the deadlines provided by the Tennessean, which showed that the deadline for publication from November 22nd through November 24th was November 21st at 2 p.m. Central Standard Time. The obituary office was scheduled to be closed on November 22nd, beginning at 5 p.m. Central Standard Time and on Thanksgiving Day. Nevertheless, information was provided to show the obituary was published on November 24, 2017, followed by a more detailed version on November 25, 2017, and our recommendation is to close this complaint.
Make a motion to accept.
I have a motion by Mr. Cochran, a second by Mr. Davis. All in favor?
Aye.
I have the next case, number 10. It's 2017080221. Here, a complaint was internally opened upon inspection due to the respondent funeral home failing to renew its license within a requisite time period. The respondent was unlicensed from November 1st to November 13, 2018, and completed one funeral service during this unlicensed period. Respondent replied back to our request indicating that they had difficulty attempting to renew through the online module and indicated that they emailed board staff during this period indicating such. As such, we recommend a close with a letter of warning.
I think we need to make mention that the date 1/13/2018 needs to be 17, I'm assuming.
Oh, I'm sorry. Yes, thank you.
Motion to accept council's recommendation.
Second.
Motion by Mr. McKinney, second by Mr. Duffer. All in favor?
Aye.
Number 11, case number 2017082151. Here, a complaint was internally opened after an inspection of the respondent's funeral establishment. The inspector found the following discrepancies, and there are three that we'll talk about. The first is that the respondent did not have a CPL available for review. The respondent was given an opportunity to find one, but could not find one during the inspection. The second item is that a review of the GPL found that there was a discrepancy regarding the B services in that it did not agree with the beginning price caskets shown on the GPL range of prices. Immediate burial offering B lists the price of $3,300 for immediate burial, which was $2,800 to include within the price a New Point brown or Triton gray 20 gauge casket. The price of the $3,300 minus the $2,800 would equal $500 for that casket. The GPL lists the beginning price for its caskets at $1,450. Therefore, the pricing structure is not in agreement. The third item is that the direct cremation offering B does not agree with the price for a cardboard container, which is the alternative container. The direct cremation listing shows a price of $995 for services included within the direct cremation required listing. Offering B lists a price of $1,300 for direct cremation with a cardboard container. This is a price difference of $305, which is $1,300 minus $995. However, the price listed on the general price list for a cardboard container is $105, given that the two prices are not in agreement. My recommendation for these discrepancies is an authorization for a formal hearing and authorize a consent order in an amount of $750 for these 3 violations that were listed above. I will note that they previously had this in their disciplinary history back in 2011, issues with the statement of funeral goods and services in the general price list.
Motion to accept council's recommendation.
I have a motion. Is there a second?
Second.
I have a motion by Mr. McKinney, a second by Mr. Shackelford. All in favor?
Aye.
Opposed?
Number 12, 2018-000091. Here, a complainant alleged that the respondent funeral home failed to complete a death certificate. The respondent was the initial funeral home that received the remains from the VA hospital in Murfreesboro. Soon after, the deceased family asked that the remains be released to a second funeral home. The board staff contacted Vital Records at the Department of Health and found that the physician does not yet use an electronic signature for signing the death certificate. In mid-January, the board office received notification that the death certificate was signed and available. Board staff immediately communicated this to the complainant. The respondent was not found to be responsible for the delay in processing of the death certificate. As such, I recommend closure of this complaint.
Motion to accept.
Second.
Motion by Mr. Cochran, a second by Mr. Davis. All in favor?
Aye.
Number 13, case number 2018-000151. Here, a complainant states that his mother had passed away in November of 2017 and was buried soon after. The family representative was complainant's sister, and she signed the statement of funeral goods and services. The complainant was present at the time the services were made. The complainant states that after the funeral, he was made aware of a will that supposedly indicated that he would be a co-executor of the estate. The complainant alleged that he requested a meeting with the respondent to review all documents, including a life insurance policy that he had questions about in relation to the actual cost of the services rendered. The complainant states that the respondent funeral home would not contact or meet with him regarding this matter. The respondent replied indicating that it did not have copies of any further life insurance policies other than one Guardian life insurance policy, which they provided a copy of, with a copy of the statement of funeral goods and services signed by the sister. The respondent stated that it had responded to the complainant at least 3 times, that his sister had handled the funeral matters, the burial matters, and that complainant had threatened the establishment. A document signed by the sister states that the funeral home does not have a copy of the will or any other insurance documents other than those given to them by their deceased mother in 2012. This office, as part of our complaint process, never received a copy of a will. It's uncertain as to whether any of the parties have a copy of the will. The respondent states that the complainant never stated that he had a copy of the will, only that he was made aware of a will. There is not sufficient information to show that the respondent is in violation of any of its duties as to the treatment of its customers or relatives of the deceased in reviewing this complaint. As such, I recommend to close this matter.
Motion to accept.
Second.
I have a motion by Mr. Duffer, a second by Mr. Cochran. All in favor?
Aye.
Thank you. Number 14, 2018-000131. Here, a complaint alleged that the respondent failed to make payment on a contractual obligation to an embalmer. The respondent disputes the contracted amount. Sorry, I ran that a little short on their summary. The amount was actually for an embalming, and I'll put this in here, of $150 is what the establishment indicated they pay, and the funeral embalmer says that he charges $165 plus, I believe it was $35 for a cleansing. My recommendation would be authorization for a formal hearing, authorize a consent order for an amount of $250, which would be reduced to a letter of warning if the respondent can provide us documentation reflecting a total payment within 30 days of the charges by the complainant.
Motion to accept council's recommendation.
Second.
Motion by Mr. McKinney, a second by Mr. Duffer. All in favor?
Aye.
Thank you. That concludes the legal report.
Thank you, Mr. Glandor. Next, we have our director's report. Mr. Gribble?
Thank you, Mr. President. First, we want to talk about the legislative update, and if you have questions, Ms. Hooper said that she would be glad to answer those questions. If you look on your iPads there, this is Senate Bill 17, House Bill 1611. It has to do with the sunset laws. As enacted, it extends the Board of Funeral Directors and Embalmers for 6 years to a new expiration date of June 30th, 2024. This has been passed. It's a public chapter 500. And beyond these first two pages that contain the bills, then the public chapter or the bill itself is contained. Find that if you want to read the bill. Mr. Rahm attended the Senate Government Operations Committee and spoke to them about, he was asked to attend and spoke to them process when this when this law was being considered in the extension of the board. I think that was on February, Mr. Rahm, somewhere along in there, that you came in Operations Committee. Next one is Senate Bill 2458, House Bill 2537, has to do with professions and occupations. As introduced, establishes apprentice programs for professions regulated by entities administratively attached to the division, which could possibly affect funeral directing and maybe embalming. Senate Bill 1876, House Bill 2305, has to do with sales tax. As introduced, exempts sales of caskets from sales and use tax. Senate Bill 1948, House Bill 1891, has to do with pre-need trust. As introduced, authorizes a trustee to establish a single trust for all pre-need funeral contracts issued by multiple pre-need sellers instead of having to establish a trust for each pre-need seller. Bill 2091 and House Bill 1889 has to do with pre-need funeral contracts. As introduced, lessens the amount of time that a seller of a pre-need funeral contract has to retain records concerning the pre-need funeral contract and information relating to the sale from 5 years after the death of the beneficiary to a new time period of 3 years. And Senate Bill 1943 and House Bill 2179 has to do with pre-need funeral contracts. As introduced, provides that a contract between a purchaser of a pre-need funeral contract and a travel protection service provider is not a contract of insurance. It's also was amended to say it's not to be regulated by Bureau of Services, and it's my understanding that may have passed. I'm not sure. It was before some committees yesterday. But those first three bills would directly affect the Board of Funeral Directors and Embalmers. The others would affect funeral directors who are practicing in the state. And like I say, I'll be glad to answer things I know about. Ms. Hooper says she'll be glad to answer questions if you have any of those. Always want to make the board aware of those bills that are in the legislature that do affect. We do not have any closed establishments to report at this time. The licensee report, the report of license is administratively approved by the Executive Director pursuant to Board authority for the period of January 9, 2018 through March 12, 2018 is presented for you there. Different establishments, changes of ownership, change of location, a new establishment, and then individuals who were issued a license. Some funeral director, some embalmer, some both, and some by reciprocity. disciplinary action report. This is a report of consent orders that have been administratively accepted or approved by the Executive Director pursuant to Board authority as reported on the December 2017 and January 2018 Regulatory Board's disciplinary action reports. And you'll see a list there that includes the firms, the violations, and the civil penalties that were paid. Last would be a complaint report. As of yesterday, we had a total of 80 complaints. 28 of those were in the funeral director and embalmer, and 52 were regarding establishments, for a total number of complaints of 80 as of yesterday. Mr. President, that concludes my report.
Thank you, Mr. Gribble.
Motion to accept director's report.
Second.
I have a motion by Mr. McKinney, a second by Mr. Duffer. All in favor?
Aye.
Next item on the agenda, rulemaking. Mrs. Hooper?
Yes, I want to make sure no one else needs a hard copy of the rules before we begin. Does everyone have a hard copy? Thank you. So today we're reviewing these rules for adoption. What you have before you is the closest thing to a final draft that we have developed thus far. This would not necessarily be the final draft. There could be minor changes between now and the rulemaking hearing. Any major changes that were identified by legal or the administration would be brought back before you for review prior to any rulemaking hearing. If you take a look at the rules, not much has changed since you all last reviewed these, but I do want to point out one change that was significant. If you turn to page 11 of the red line, and look at paragraph H at the top, that has been changed. Initially, it said that a person who engages in such conduct shall be revoked. Now it reads as follows. The license of any licensee whom the board finds has engaged in sexual misconduct with a dead human body may be revoked by the board. If the board determines disciplinary action that does not include revocation is appropriate in any case involving sexual misconduct, the board shall issue a finding of no good cause for revocation and thoroughly explain the mitigating circumstances in any order, whether by consent or otherwise. So I did want to direct your attention to that. That was the only change that I would consider significant since you all last reviewed these rules. Did anyone have any questions about that particular change?
One quick question. I guess it's understood that when it says the licensee, we're referring specifically to the individual, not to the establishment, or is that?
It could be both.
It could be
because
both.
they're
Okay.
both.
I'm just curious.
Both of them are considered licensees, and so
Okay.
you all would have discretion with either the establishment or the individual license. But the idea would be that if for any reason you all did not think revocation was appropriate, you would essentially need to justify it in writing thoroughly. Were there any questions about these rules in general before we move to adoption?
We adopt these today. What's our next step?
One of the things I would seek from you all today is authority to set a rulemaking hearing. And so what I would do is then circulate these rules for further review by our legal department and our administrative department. And again, as long as there were no major changes, I would move forward with setting a rulemaking hearing, and you all would have that hearing probably, I would estimate 3 months from now, 3 to 4 months from now, and move forward accordingly. A lot of it depends on our internal review, because we do need to review it for constitutionality again and those types of things, which take time. We didn't discuss these documents, but they're also in front of you. You have your, it's called a regulatory flex analysis. You have that in front of you, and also the governor's questions. Did you all get a chance to look over those as well? Any questions about those? If there are no questions, then I would need a motion and a roll call vote to adopt these rules.
Motion to adopt.
Second.
I have a motion by Mr. McKinney, a second by Mr. Cochran. Mrs. Bohannon, would you call the roll?
Mark Cawthorn,
Yes.
Robert Davis,
Yes.
Jeff Duffer,
Yes.
Clark McKinney,
Yes.
Charles Rahm,
Yes.
Robert Shackelford III.
Yes.
I have 6 yes, Mr. President. Sorry.
As far as the hearing is concerned, Mrs. Hooper, is that something that we also have in form of a motion?
I would just ask, yes, I would ask that you all motion to allow me the authority to set a rulemaking hearing as soon as practicable in 2018.
So move.
Second.
I have a motion by Mr. McKinney, a second by Mr. Duffer, to allow Mrs. Hooper the leeway to set up a hearing at the earliest possible convenience.
Roll call on that one.
It won't hurt.
All right. Ms. Bohannon?
Mark Cawthorn,
Yes.
Robert Davis, Jeff Duffer,
Yes.
Clark McKinney,
Yes.
Charles Rahm,
Yes.
Robert Shackelford III.
Yes.
Mr. President, we have 6 yes.
Thank you.
Thank you. That concludes the portion of the meeting that relates to rulemaking.
Thank you very much. Next, we have our license applications.
Mr. President, you have one individual to come before you today. It's Jackson Hunter, who is from Watertown, Tennessee. He's making application for an embalmer's license. He is currently a funeral director, license number 6381, that was issued November 16, 2010. And he's before you today for consideration of an embalmer's application. If you want to, Mr. Hunter, just to
Mr. President, I need to recuse myself today on this one.
All right. Let it be noted that Mr. McKinney is recusing himself. Questions or comments from the board?
Well, okay, lights up automatically. Well, I've grown up in the funeral business, been around the funeral business. Growing up in it, I mean, you see that it's a lot of work. I often thought to myself, I want a normal job with normal hours, but it's kind of being from a small town and being a third generation funeral director. At some point, I mean, I felt a responsibility to carry that on in my community, and 2007, I lost my sister, Polly, to cancer. And looking back at my life at that time, I mean, I kind of started asking some questions. Why her and not me? Till that point, I'd really been nothing but trouble. I was in a college fraternity and kind of immersed in that culture, and I mean, made a lot of bad decisions. Finally struck me that I can't do anything to bring her back, but to honor her memory, I could become a better person, and I set out to do that. I applied for an apprenticeship and had the privilege of receiving my funeral director's license in 2010. And since then, I've received a bachelor's degree from Middle Tennessee State University. I had the opportunity to study abroad in YAMP University in Jyväskylä, Finland. I also enrolled at John A. Gupton College and earned my degree this last December. I worked very hard. I was valedictorian in my class, and I mean, I look to do nothing more than to prove myself each and every day to this board, who has given me the privilege to be a funeral director in the state of Tennessee. Thank you.
Since becoming a funeral director, you've not had any issues, is that correct?
No, sir.
Honor, personally, I would just like to commend you for the efforts you have demonstrated to turn your life around. It looks like you had a pretty rough stretch there from about 10 or 11 years, but the last 11 or 12, obviously you've been a different person and have excelled in your education at Gupton's, and just as a personal remark, I commend you for that effort that you made.
I'll make a motion to grant his license.
Second.
I have a motion by Mr. Duffer, a second by Mr. Cochran. All in favor?
Aye.
Any opposed? Congratulations. Best of luck to you.
Thank you very much.
I have no new business to bring to you. I don't know if you have any of the board members do, but I have nothing to report to you.
Thank you, Mr. Gribble. Any board members have any business, new business? I'll entertain a motion to adjourn.
So move.
Second.
We're adjourned.